Hello everyone, welcome to the Aspirant Diaries. In this video, we will understand one of the earliest and the most important constitutional case of the India, the Berubari Union Case of 1960. This case answers the very fundamental question, can India give away its territory to the another country without amending the constitution? Let us understand, but firstly have a look on the background of the case. After independence, the Radcliffe Award of the 1947 divided the India and the Pakistan. However, the boundary was not very clear in the certain areas, like in the area of the eastern Pakistan and the India. One of such area was a Berubari Union, which was located in the West Bengal. In 1948, India and the Pakistan signed the Nehru-Noon Agreement. So, in the Nehru-Noon Agreement, there was a proposal to divide the Berubari Union and enclaves would be exchanged between the two countries. So, this created a constitutional doubt in the India that the government of India asked, can this transfer be done first by an executive agreement? Like Nehru-Noon Agreement was an executive agreement. So, under Article 3 of the Constitution, which deals with the reorganization of the states, or does it require the constitutional amendment? To resolve this, the President refers the matter to the Supreme Court under the Article 143. As we know, 143 is the advisory jurisdiction where the President asks to the Supreme Court regarding any matter of conflict or any matter where the President wants advice of the Supreme Court. So, in this issue, the court had to decide the three questions. Firstly, does Article 3 allow the cession of the Indian territory to the foreign country? Can Parliament transfer the territory by any ordinary law? Is a constitutional amendment under Article 368 is compulsory? So, the Supreme Court of the India made a clear distinction. Article 3 allows first formation of the new states and second alteration of the state boundaries, but it deals only with the internal adjustment within the India. So, ceding the territory to the another country is not the internal matter. The court held that the cession of the territory affects the sovereignty of the India and it directly impacts the Article 1 which defines the territory of the India. So, therefore, executive action is not enough and ordinary legislation is not enough in this case. So as we see, Article 1 is all about it and Supreme Court held Article 3 is insufficient. So the final judgment that the Supreme Court of India gave was the cession of the Indian territory requires the constitutional amendment under Article 368 and Article 3 cannot be used to give the Indian land to the foreign state. So what was the aftermath? So basically the Parliament passed the 9th Constitutional Amendment Act of 1960 which legally enabled the transfer of Berubari Union. This case established the three key principles. First, the territorial integrity is constitutionally protected. Second, the executive agreement cannot override the constitution. And third, sovereignty changes need the constitutional approval. So, in short, if we have to look on it, Article 3 is about the internal matters and Article 368 is about externally. If we want to share our territory with any foreign state, it will be completely sovereign matters. So, Article 368 comes into the consideration. So, if we look into the recent changes, so in the 2015, the land boundary agreement of 2015 between the India and the Bangladesh, we have shared some enclaves with them, like with the Bangladesh as well. So Article 368 was followed and parliamentary approval, state consent of the West Bengal and the Assam was taken. So if you found this explanation about the Berubari Union case useful, please let me know in the comment section, and in the next video we will move to the another case to explore the landmark judgments in the India. Thank you so much.